abduction, kidnapping, enforced disappearance, arbitrary or unlawful arrest and/or detention. What acts or situations constitute the presence of the risk? This protection risk covers 4 different acts and measures of detention. Abduction and kidnapping refer to removal, seizure, capture, apprehension, taking or enforced disappearance of a person either temporarily or permanently, without support or acquiescence of the state. When the victims are children, it constitutes a grave violation. It engages obligations of the state to investigate and to prosecute those responsible. Enforced disappearance is constituted by 3 cumulative elements. The person is detained or otherwise deprived of liberty. The deprivation of liberty is carried out by state agents or by persons or groups of persons acting with their support or acquiescence. Those responsible refuse to acknowledge the detention or conceal the concerned person's fate or whereabouts, placing the person outside the protection of the law. Unlawful arrest describes the initial act of taking a person into detention that is not based on either a criminal charge or another reason provided for by law. Arbitrary arrest or arbitrary detention refer to the situation where the arrest or detention is not justified by a legitimate purpose, reasonable, appropriate, and necessary in the individual's particular circumstance. What factors must be identified for monitoring? While monitoring this protection risk, it is fundamental to understand the nature and the conditions of detention. A detention is considered unlawful when it is not in accordance with national laws and the procedures established by law. A detention is arbitrary when it is inappropriate, unjust, unreasonable, or unnecessary in the circumstances. Child abduction may also constitute a form of child trafficking where the child is exploited in whatever form, requiring an investigation of the related protection risk. What information and data can illustrate the presence of the risk? Generally, in situation of armed conflict, there is information on such types of incidents and targeting, but not during the period when the risk is occurring. This data and information is often collected by human rights partners, actors and mechanisms, or by UN missions or other protection of civilians mechanisms, national institutions, ombudsmen, or special bodies pertaining to the legal and justice system may have information and data. Research and analysis centers, media and protection monitoring can provide additional indication on possible presence of cases and incidents. Often it may not be possible to have precise numbers or statistics due to access and other constraints. It is therefore important to use observation, expert judgment, triangulate available information, and ensure reporting on the protection risk, independently from available statistics.